Hi everyone, welcome to today's webinar. We're just waiting for a couple more people to join, so we'll get things underway in just a minute or two. But hope you're all doing well this morning, and yeah, we'll get things underway in just another couple of minutes. Okay, well, we might get things started. Um, Welcome everyone to today's webinar on preparing your business for Labour's plan to make work pay and what it means for employers. So by way of a couple of quick introductions, my name is Simon Obee and I'm head of HR advisory at Employment Hero. At Employment Hero, we exist to make work easier and more rewarding. We do that by providing HR and payroll software, but we also have our HR advisory service where businesses get access to unlimited employment advice from a team of HR experts, also unlimited access to HR documents such as policies, contracts, all that sort of stuff, and also representation if an employee brings a claim. So that's us at Employment Hero, but I'm also joined today by two brilliant employment lawyers from Oury Clark. Oury Clark and Employment Hero have worked together for many years, so it's great when we get to do things together like this. So we've got Jess Bass and Ross Meadows from Oury Clark. Do you want to tell us a bit about Oury Clark and what you guys do there?
Yeah, sure. Yeah, good morning, everyone. My name's Ross, and I'm with Jess. We're both employment lawyers at Oury Clark. Um, we act for businesses, whether you're small, medium, large. We act for everyone, different sectors. And as part of the Oury Clark business, we're more than just lawyers. So we have a full range of legal services, but we're a one-stop shop professional service. So we can also support you on your accounting, tax, your payroll, and other areas and services. So we have a full range of services that can support businesses in the UK.
Great, thanks, Ross, and great to have you on board too, Jess.
Thank you.
All right, well, let's just start off with a little bit of housekeeping. So we're going to run for an hour. We'll try to keep things to time because I'm sure everyone's got a busy day. The webinar will be recorded, so if you do need to leave early for any reason, don't worry, we'll be sending out a copy of the webinar and also a copy of the slides too. So if you have any questions that you want to ask, if you can use the Q&A function rather than the chat function, that just makes it a lot easier for us to keep track of everything. And just to try and keep to time, we'll keep the questions to the end and we'll try and address some of those at the end. But if we don't get to all of the questions, which I'm sure we won't, we will put together an FAQ document afterwards and try and answer those. So if you do have any questions, just stick them in the Q&A. And we will get to them when we can. I think that was about all I needed to say for housekeeping. Just a quick disclaimer that you can read in your own time, but this information we're going to provide is general in nature. It shouldn't be relied upon as legal advice. And if you do need any assistance on your own individual circumstances, just reach out to us at Employment Hero or to Oury Clark, and I'm sure one of us will be able to help you. Okay, so let's get things underway. We are talking today about the government's plan to make work pay, delivering a new deal for working people. So when the Labour administration came in to office, they had published this document prior to the election, which sets out their plans for employment law reform. And as you would expect, with the new government coming into power, there are various changes they want to put forward. And as the title of the document suggests, plan to make work pay, a lot of these are quite pro-employee, pushing sort of employee rights, as we shall see. So the government have committed to introducing legislation to bring these changes into effect within the first 100 days of office. So that is the 12th of October. That doesn't mean these changes are going to actually come into effect on the 12th of October. The legislation will have to be introduced into Parliament. It'll be debated, so it may be some time before some of these changes come into effect. The other thing to note, of course, is we don't know exactly what the legislation is going to look like, how it will finally be made. So a lot of this stuff is still a bit vague from the government's announcements, but at the very least, we'll be able to kind of give you some signposts to the sorts of things that are going to be coming into the employment law world over the next period of time. But if you stay in touch with us at Employment Hero and at Oury Clark, we'll keep you informed as we get that information. So what are we going to talk about today? Day one rights, 0 hours contracts, fire and rehire, flexible working, and enhanced maternity protections. These are all things that the government is looking to reform. So let's jump into it. So starting off with day one rights, just as a kind of general comment, as I'm sure you're aware, in employment, employees, some things, some rights they get access to from the first day of their employment. Other things they tend to get access to after they've been employed for a period of time. Ross and Jess, can you talk to us a bit about what is proposed in these areas and how what businesses should be thinking about to get ready for some of these changes?
Or Jess, do you want to go?
Yeah, I'll go. So the proposal at the moment is to introduce day one unfair dismissal protection. So at the moment, there's a 2-year qualifying period for what we call ordinary unfair dismissal. So that's a dismissal without something such as, whistleblowing, asserting a health and safety concern, something like that. So at the moment, first 2 years, within reason, you don't need a reason for dismissing. After that, you have to go through and give one of the 5 fair reasons for dismissal and also follow a fair process. So what Labour are proposing is that they're going to get rid of that requirement effectively. So from day one, you would need a fair reason and a fair process. They've said it's going to be subject to a reasonable probation period. We don't know what that looks like, and obviously what the kind of impact of that is going to be. Our kind of main concern with that is it's presumably going to increase employment tribunal claims, because there's some trickier loops to jump through in terms of what the real reason is, and also following that kind of fair process. Should I carry on? Yeah.
Yeah, I mean, keep going. I mean, I suppose
Yeah.
it does, on the face of it, it sounds concerning that businesses are used to having this 2-year period whereby you can kind of work out whether someone is a good fit for the organization or not, and generally speaking, you can make that decision within the first 2 years about letting them go without many repercussions. So when you hear about unfair dismissal being a right from day one, it does sound concerning. But if there is this exception for having a probationary period, and as long as they're in a probationary period, unfair dismissal won't be a right that they get. That would seem to kind of alleviate some of those fears, I guess. But I suppose it's going to be really important for employment contracts to be drafted properly and to make a clear reference to a probationary period. So hopefully that there is still some ways to kind of practically have an ability to bring someone on and make up your mind whether they're a good fit or not.
Yeah, and
But I
it'll
guess
it'll be interesting how they introduce it. Like I say, the devil will be in the detail, the legislation, which they're promising on the 12th of October. Probably another 6 months might pass before we get there with this. And there's probably a couple of ways. The most draconian option is that it is a purely day one right. That doesn't make real sense of a probationary period, but it's probably where the probationary period, there's a certain procedure during that period. Or they actually reduce it from 2 years to say 6 months, which is a typical probationary period. So that in the first 6 months, as long as it's a probationary period, and I think the key there will be you need to look at your employment practices, look at your contract, introduce probationary periods if you haven't before, and ensure that that's you're ready for when this comes into effect. They may do that. It may not be a purely day one right. In terms of history, and I'm probably showing my age here, when Tony Blair's Labour government came into power, they promised unfair dismissal would be a day one right, and it became 12 months instead of the 2 years. So I'm sure there's, like we say, a lot of devils in the detail, and there will be consultation. They promise to consult with businesses, with workers, with the general public to get the balance right, and we just have to wait and see.
Okay, very good. But it's not just unfair dismissal which is proposed to be a day one right. So parental leave and access to statutory sick pay also on the agenda, as it were. What do you think the impact of introducing those as day one rights is going to be?
It'll just be more admin, more cost for the employer. Again, it's back to your procedures that you have in place. That suddenly parental leave, which is normally after a year, becomes a day one right, and being aware that will be the shift under this Labour government. With sick pay, there's a waiting period, so it's normally day 4 of the absence that statutory sick pay kicks in. So again, a bit more admin. Look at your pay. It's one for payroll to make sure that they get the right information that someone's sick. I mean, many employers probably sometimes offer full pay for the first week, first few days anyway. So there might not be any major shift. But yeah, it suddenly becomes day one, the statutory sick pay entitlement.
Yeah, and I suppose with parental leave, one of the impacts of that is, oh, sorry, I've jumped ahead, haven't I? One of the impacts of that is probably going to be, at the moment, if you're a business and you have someone who joins the business and they're already pregnant, or perhaps they get pregnant shortly afterwards, they don't have access to the statutory parental leave. So the consequence of that, practically speaking, is usually that they don't have a right to return to work after they've given birth. So you have a lot of people that they resign from their employment, and they go off to have their child. But one of the big impacts, I suppose, of making it a day one right is that at any point of giving birth, no matter how long you've been employed, you're going to have that right to come back to your job after your parental leave has finished. That seems to me to be a sort of a fairly significant development in this area.
Yeah, and I
Yeah.
mean, I was just looking at some of the comments as well, Simon, and one of them was, I just won't hire, and that's, you know, when you've got quite balanced laws. I mean, it depends what side of the fence you sat on, but that this shift will make employers think twice about hiring staff because of the extra cost and admin. It will be a massive shift. I mean, they describe it as the biggest changes since the 1970s.
Yeah.
Yeah, and on the parental leave point, Labour have just said that they're going to review parental leave. Now that covers loads and loads of different aspects potentially, and we don't know whether they are going to be reviewing you know, maternity rights and things like that, other than something that we'll come back to later. Or what they're going to include for that. And we also don't know whether they're going to review the pay aspects connected. So the right to leave and the right to pay are different. So we're just not sure at the moment on what they're sort of suggesting and what they're proposing. But there are, you know, there are going to probably be unintended consequences, as Ross has mentioned in the comments about not hiring, and that's going to be something that's going to have to be raised during those consultations with, you know, with businesses, with industry professionals, with employment lawyers, people like that. Those concerns are all going to have to be looked at, as these ideas may sound fantastic for employees in you know, on paper, but actually the reality is it's probably going to have these unintended consequences that might make it harder.
Yeah, absolutely. Well, I think it's definitely one to keep an eye on, and we'll see how these things develop, and of course report back to everyone when we get more news. So, anything final comments on day one rights you guys wanted to pick up on?
I think the major takeaway is unfair dismissal, because a lot of particularly in the SME world, a lot of employers, if it's not working out in the first 2 years, you know, absent of discrimination or whistleblowing complaint, you can have a more straightforward discussion. The fact is that you don't hire someone to fire them. You know, that is not the concept. Unfortunately, when you recruit, it sometimes does not work out, and that was what the 2 year period allowed. It allowed the employer time to assess that employee rather than making a knee-jerk reaction.
Yeah, I do agree. I think that is one that's going to cause a lot of concern. But yeah, we'll have to see, because if the probationary period is an exception, then you would think, as long as your contracts are properly drafted, that hopefully is going to allow businesses a degree of flexibility. But yeah, we're going to have to wait and see. Okay, all right. Well, let's move on to 0 hours contracts. So, as people will probably know, one of the ways that individuals can be engaged currently and perfectly lawfully is through a 0 hours contract. That's the idea that the employer isn't committing to providing a minimum number of hours, hence 0 hours. And you know, that is obviously a very useful way to engage someone flexibly. You might be just looking for someone for a particularly busy period, you know, the Christmas rush in retail, or a particularly busy time in hospitality, or you might be doing a one-off sort of event where you just need casual staff. The Labour government have announced that they want to reduce the ability of businesses to use 0 hours contracts. Can you tell us a bit more about what that is likely to look at, and I suppose what they're trying to what is the problem they're trying to address there?
Yeah. So the proposal is basically to outlaw exploitative 0 hours contracts, and that's obviously not been defined yet. We don't know what that means, what what that kind of covers. It's really about an attempt to remove what we call one-sided flexibility. So with all the flexibility being on the employer to be able to say, right, I need you now, or with minimal notice, I don't need you anymore, to come and do those shifts, because obviously if people aren't working those shifts, then they're not getting paid. And the idea is to create a bit more stability for employees to be able to request a predictable working hours and things like that, working pattern or minimum number, based on a sort of 12-week reference period. We don't really have any detail at the moment on how that minimum hours is going to be really judged or enforced, or whether employers can resist sort of the request to have this average hours contract. So that's kind of the point on the exploitative part. The other part of that legislation that they're going to propose is to basically give reasonable notice of shifts that people are required to work, and also to give compensation if shifts are cancelled at short notice. So again, we don't really know, but they've said it's going to be proportionate to the cancelled shifts. So there might be a minimum time frame, say 48 hours or something like that before a shift. Otherwise you may end up having to pay either the cost of the shift, half the cost. We just don't know on that point. And the idea is really to kind of introduce that certainty for employees. There's obviously going to be unintended consequences again on that. Ross, do you want me to go through that one, or do you want to pick?
Yeah, keep going.
Yeah,
Thanks,
cool.
Jess.
Yeah, so our concern is that these do offer flexibility for a lot of people, and there's a lot of people that like 0 hours contract and being able to say, I can work more shifts. University students, people that might have second jobs, people like that, they're actually quite useful. Our concern is really that reduction in flexibility is obviously going to increase employers' costs. It could create resourcing challenges. So as you've mentioned, retail, events, things like that. Seasonal surges, how are they going to be tackled? Is it just going to be that you're going to have to just rely on temps, or offering overtime to people that you've already got? It's going to create a higher demand on managers to put in place sort of rosters, and having that ability to sort of anticipate future needs and busy periods. So you may end up overscheduling things, you may end up underscheduling things, and really how is that going to be dealt with? Are you going to end up having to pay sort of that compensation? We just don't know at the moment.
Yeah, I mean, 0 hours has been debated for many years now. I remember the head of Sports Direct being questioned, by the government on how staff are treated at Sports Direct who are on 0 hours. So what they did, a lot of companies rebranded it as a casual worker contract. It sounds a bit nicer than 0 hours, but ultimately, the government were initially saying they were going to do an outright ban, which would have been madness, because as Simon and Jess say, that there are businesses, there are sectors where there will be demand for 0 hours, where you need people flexibly, and also this works for certain people, that to have that flexibility with what a 0 hour contract offers. I think as Jess says, it's going to be more admin, more keeping a record of your arrangements with people on 0 hours, because of that 12-week right to get minimum hours if there's a regular work pattern. It may lead to you actually, some businesses using 0 hours, having a bigger pool, but not using as many people, so it doesn't trigger some of these changes, where before they wouldn't have been concerned. The whole purpose of a 0 hours contract, if you're classified as a worker, there's no obligation to offer you work, and there's no obligation for you to accept work. There is another medium of a 0 hours employee where if you're offered, you should accept. You know, that's the shift. But the whole point of 0 hours is always that they should be flexible, and it sounds like a lot of that will be taken away.
Yeah, I mean, again, yeah, I totally agree. It does sound very concerning. I mean, if it's not a complete ban on 0 hours contracts, and it is just stopping them being used in certain circumstances, that sounds more workable. I mean, I guess if you have a 12-week period and someone is working irregularly in that 12-week period, and that means they don't need to be given a minimum number of hours, then that's, that sounds okay. And if it's only people who've ended up working 9 to 5 for 12 weeks, but to get that right, that sounds more manageable. But as you say, that if that is how the legislation is going to be expressed, it's going to really put an onus on the employer to make sure that they are deliberately rostering people so they work irregular hours, and that's just another bit of bureaucracy and loophole and hurdles they're going to have to jump over, which they wouldn't have been too concerned about before. So yeah, I guess it's another one that we need to keep an eye on, and hopefully the legislation is expressed in a way that where there is a genuine need for a 0 hours contract, that should still be possible to rely on. So any further thoughts on that, or should we keep going?
I think we keep going.
Yeah, let's
Yeah,
go.
all right.
Yeah.
Let's keep going. All right, firing and rehiring. I mean, I think this is it's on a similar theme to the proposed 0 hours contract reforms, I suppose. So as people hopefully are aware, the kind of general position with an employment contract that's agreed between an employer and an employee is it can't be changed without both parties agreeing. So sometimes businesses find themselves in a situation where they genuinely need to change a individual's terms and conditions, perhaps a change to what they're paid or the hours they work, due to genuine business needs. If that can't be done by agreement, then sometimes a business finds himself in a situation where they need to terminate the contract, offer the employee a new contract on different terms, and that is what we mean when we say fire and rehire. There's some proposed reforms in this area too. Can you talk us a bit more about what is proposed here?
Yeah. So the proposal is basically there'll be a prohibition on fire and rehire. So similar to sort of the P&O scandal that happened a few years ago, where employees were dismissed and then offered re-engagement on substantially different terms. The proposal is that will be banned. There was a new statutory code brought in on fire and rehire, so via ACAS, that Labour have said is not fit for purpose. So the proposal is to get rid of that and say that you can't fire and rehire except in circumstances where basically your business just wouldn't be able to continue without doing it. Again, devil's in detail, we don't have that yet, but that's the kind of the proposal for now, and that could put a severe sort of restriction on a business's ability to be able to change people's contracts where they don't agree, for example. If there's a substantial change in how they work that it falls short of, let's say, a redundancy situation, it's going to impact things like that.
Yeah, and I think the key areas highlighted by Labour for these changes is that they're going to improve information and consultation procedures. That was the whole purpose of this new code of practice. And you've got to remember that there's existing laws on unfair dismissal that can bite where there's inadequate consultation, obviously subject to the 2-year rule. They've also talked about adapting unfair dismissal and redundancy legislation to prevent employees from being dismissed for failing to agree to a contract on less favourable terms. And then there's talk of bringing the trade unions in, sort of a notice and ballot to consult on this as well. So that they're really, it sounds like there's not going to be any fire and rehire. It's more likely there's going to be just, we're going to fire you. That's what I think this will lead to if it goes to the extreme that was initially proposed in the manifesto.
Yeah, absolutely. I mean, I guess if it's expressed in a way that you can't fire and rehire, unless there is a genuine business need to, or unless it's a kind of last resort, that's something. But if it is an outright ban, it does seem like that's going to be something that businesses are going to really have to think about quite carefully. But again, with all of these things, we're going to have to wait and see exactly how it's expressed. But definitely something to keep an eye on. All right, in the interest of time, we'll keep ploughing ahead. So flexible working. So this is something which is a big thrust in the Make Work Pay document. I guess in terms of how the law currently works, employees already have this statutory right to make a flexible working request. So that could be to work part-time, it could be to work from home. That's already protected under employment legislation, and that's been a day one right for employees from April. So the consequence of it being protected under employment law, I suppose, is that an employer has to consider that request when they receive it, and the legislation sets out the process they must follow in dealing with that, and they can only refuse it on reasonable grounds. So there's already these protections for employees. So what is proposed to change in this area, and is this something that businesses need to be concerned about?
Yeah, so the proposal is to make it that flexible working is the default from day one, except where it's not reasonably feasible. And as you've said, there's already a statutory, a legal right to request flexible working. There's a process that employers have to follow if they get a statutory flexible working request, and there's limited grounds on which you can reasonably refuse that, and that's sort of things like extra costs that might damage the business, work can't be reorganized, it'll affect performance, it'll affect quality, it'll affect those sorts of things. Now obviously there's some jobs that we just know it's never going to be possible to have flexible working for those sorts of things. Let's say you need somebody on reception to greet people coming in between the hours of 9 and 5. It's no use to you if your employee then says to you, oh okay, but I want to do it from 3 o'clock in the afternoon until 8 p.m. That's not going to be reasonably feasible. So again, we don't know, but we suspect that the reasons for refusing are probably going to mirror the existing reasons within that right to request. So at the moment, it's a right to request. Labour seem to be suggesting a right to have it, but there's still going to need to be that reasonable, reasonableness of it actually working in practice. So my kind of view on this one is it's probably the right is already there to request it. This is now a right to effectively demand it, but actually looking at the current system, if employees do put a formal statutory working request in, you've got fairly limited grounds to refuse it anyway if it genuinely does work for the business. So it'll be interesting to see what the kind of restrictions are on when it's not, when you don't have to permit it, and whether it fits in with what the existing reasons to refuse an application are.
Yeah, I mean, what I would say is when these cases go to the employment tribunal, subject to a discrimination claim that's thrown in as well, employment tribunals generally do not want to look behind the employer's reasons, because they're business reasons. They want to. This is one of the areas where the business reasons, they'll have the business reasons. They can't substitute their own reasoning for that. And what this sort of suggests to me is that actually there's going to be a bit more flexibility there of saying, well, I think you should have done it this way, and that, until we see as far as is reasonable what that means, and it might mean that there's just a little bit more persuasion required if a case went to a tribunal.
Yeah, absolutely. I think this is one area where it seems like there is a bit of confusion. There was I'm not sure if you saw some articles in the newspaper over the last week about a leaked memo saying that all workers are going to have a right to request to work a 4-day week, so compress their 5 days of work into 4 days. But of course, employers already have a right to make those requests, and there is an ability for employers to refuse those as long as it's reasonable to do so. And as Jess illustrated, there's going to be some jobs where it's completely obvious that someone only coming into the office for 4 days isn't gonna work. So as long as there is still this reasonableness test, hopefully this is still going to be workable for businesses. I suppose one possibility might be that they increase the penalties for refusing something when it wasn't reasonable to do so, or perhaps something like that. But we'll have to wait and see on that one too. Okay, so let's keep going. Enhanced maternity protection. So do you want to talk us through what's proposed here?
Yeah, absolutely. So Labour's proposal at the moment is to make it unlawful to basically dismiss a woman who's had a baby during that 6-month period after a return to work. It says in except in specific circumstances. Now, from this year, there were enhanced rights for women on their return from redundancy, in redundancy situations. So they had a priority right to be offered suitable alternative employment during their pregnancy period, and also within a protected period after they'd had the baby. The proposal is to basically extend that quite far, and make it unlawful to dismiss within 6 months of the return. Presumably that's also going to apply during the pregnancy and the maternity period itself, but again, we don't know. I mean, the specific circumstances, again, we don't know. So is that going to be where there's been a genuine pre-existing performance issue? Is it for misconduct where it's only, gross misconduct? We just don't know at this point. And, my concern with this one is the unintended consequences and what it's going to do. I mean, the reality of the situation is that if you dismiss somebody immediately on their return from maternity, quite a lot of the time you're probably going to be worried about a pregnancy and maternity discrimination claim anyway. Obviously circumstances dependent, but there's already this kind of, you're already at risk. And my fear, and certainly a fear of a lot of people my age, is that it's going to have the unintended consequence that people will stop hiring people of a certain age, and that might be the impact, which obviously would be discriminatory in itself, but it's certainly one of those unintended consequences that will need to be raised and considered, and that it might be counterintuitive, countercultural for a lot of supportive employers, things like that.
And I think, we'll just have to wait and see what those specific circumstances are. As long as they do make it very clear what they are. Sometimes they might just have something quite general, like a special circumstances defence, that you see in other legislation, and then it's open to interpretation. So I think that, again, the devil will be in the detail of what these specific circumstances are, and ensuring when we do know what they are, or what they're expressed to be, that your policies and procedures are in place to ensure that you don't fall foul of that protection if circumstances arise where you're looking to dismiss someone who's happened to return from maternity leave.
Yeah, absolutely. Okay, all right. Well, let's keep going now. Those were kind of what we picked out as the main proposals from the Make Work Pay policy. There are a few other things on the employment law horizon that we could just take a quick jog through. So the duty to prevent sexual harassment, I suppose a lot of what we've talked about today is still pretty vague and uncertain, whereas this is something that we know is coming into force in October of this year. So should we just have a quick chat about what is changing and what that's going to mean for employers?
Yeah, so I mean, the principle is already there that employers should take reasonable steps to prevent harassment. This is a new sort of positive obligation on them to do that. So it's coming into force next month, I think we're up to now. So really, for employers, it's going to be a case of ensuring your training, your policies, your culture and everything like that is up to date with this duty, to make sure that obviously you've got this. I mean, at the moment it's a defence for employers to show that they've taken all reasonable steps to prevent harassment in the case for a claim against them, but so this now introduces that positive obligation to make sure those steps are taken.
Yeah, I mean, hopefully businesses are already thinking about these sorts of things. But as you say, the idea is to be doing something kind of proactively, thinking about this all the time, making sure you have a proper sexual harassment policy, that your employees are trained on that, and that you're always looking for where the risks of sexual harassment might lie, and thinking about ways to address those. And I guess the idea is to be as proactive as possible. Ross, we talked the other day about the other thing that is changing is that employers are going to have to be thinking more about third-party harassment of their staff.
Yeah, there's an extension of that duty in terms of harassment by third parties. I mean, in many ways, there's legislation already in place dealing with third party harassment, but it's to deal with particular sexual harassment, and that will be an extra step that employers need to look at and ensure that they have procedures in place or have ways of dealing with the potential impact of third party sexual harassment.
Yeah, absolutely. So that's kind of stuff like harassment by a customer, or harassment by maybe like a contractor or something in the business like that. And employers having to be more concerned about that. We probably will perhaps, I mean, it's a whole area in itself, so we might well do a separate webinar on the sexual harassment duty when that comes into force. So stay tuned to that. Okay, what about the right to disconnect? Do we know what is proposed in that area yet?
Yeah, so that's basically Labour proposed this a while ago actually, and so it's definitely on their agenda. It's basically a right to not be contacted outside of your normal working hours by your employer. It's the right that does exist in other jurisdictions. So Ireland have it, Belgium have it, you know, various other places do have it. It's not it's not a automatic prohibition that they're saying. It's not an absolute right to disconnect. There's some industries where it's obviously not going to work, and it's certainly not an obligation to disconnect. So you know, there's some people might like working on a Saturday to clear their diary for a Monday and give them, you know, things that it's not an obligation that you're not allowed to work outside of your normal hours. Again, we don't know what it's going to look like. We don't know whether there's going to be people are going to start putting in wider working hours into contracts. So, you know, where they've got an opt-out already from the working time regulations, which stop people working over 48 hours a week, whether people are just going to put their working hours from, you know, 6 a.m. till whatever time in the evening and say, but you're only going to work 40 hours of that to give them flexibility. Again, we just don't know, but it is something that exists in other jurisdictions. So it's going to be workable. If it's working for other jurisdictions, it might just mean that there's going to be some changes in terms of policies, in terms of how businesses kind of approach it. And it's going to be very, very industry specific.
And I think to add to that, it's, you know, I think the worry is that, you know, if your customer demand does happen out of office and you need to deliver, particularly, you know, in the professional services industry, how will the right to disconnect impact that? It very much looks like in those circumstances where there's a necessary need, you know, it's reasonable to respond, and that might be a reasonable response, because you're going to lose a customer if they can go elsewhere and get that support. That you know, the business could go under. That might be the flexibility, but I think, as Jeff says, it may lead to situations where some businesses say we're a 24/7 business. So if we do need you to connect on certain hours, this is what it is, and your minimum hours are X.
Yeah. I mean, I know in Australia it's just come into force, and it is expressed as employees have a right to disconnect, but only insofar as it's reasonable. So hopefully, you know, as long as there is a reasonableness aspect to it, then that will be workable. Because, as you say, there are some jobs and some industries where it's just part and parcel of the role, and the business couldn't operate if the employees don't you know, have an ability or an obligation to respond to contact out of work hours. You know, global businesses where people are working across different time zones, it's, you know, it's part and parcel of the role that some out of hours contact is required. So yeah, we can hopefully there's going to be a similar approach to sort of reasonableness exemption. All right, what about introducing a single status of worker? That seems to be a pretty big change if that one goes ahead. What do we know about that one so far?
Yeah, I mean, I think, where do you start with this one? So at the moment, there's a sort of a three-tier system for employment status. So employee, worker, and then self-employed. And their proposal is to remove that distinction between employees and workers. Worker status and employment status has been battled about for, you know, years and years at this stage, and the reason is that employees and workers have different rights and things like that. So the idea is that they're going to reform that, introduce this one single status, so employees and workers are effectively considered the same. Problem is the tax doesn't fit with what the law says. So there will be potentially changes to that, potential implications. As I say, this is something that's been spoken about for absolutely ages. So I can't see that coming in. I can't see them coming up with a solution in the next month and a half, but we will see. I suspect it's going to be something that they're going to keep under review and see what happens with. And I suspect that they've got enough to be sort of looking at and introducing legislation for before tackling this issue.
Yeah, and the big issue sometimes, as well as from an employment law perspective, is the tax side. And under tax law, you're either an employee or you're self-employed. There's no middle ground of worker compared to employment law. So perhaps there could be a shift where it's just you're a worker or you're self-employed. But I think it's a general push that that the tax office are trying to drive anyway, of most people are payrolled and subject to payroll taxes.
Yeah, absolutely. Okay, and then finally, extension of time limits for bringing tribunal claims from 3 to 6 months. So I guess the obvious consequence of that is employers are more likely to face a claim from an employee if the time to bring a claim is being extended. And is there anything else that we can say about that?
Yeah, I think it's a difficult one, because I think, yes, to an extent, there probably will be an uptake of claims. People have got longer to put them in. But I also think that some people might not put claims in at that stage. So the 3-month limit is really, really short, and it's, can be extended via ACAS by up to sort of 6 weeks or so with the early conciliation period. But that short pressure puts quite a lot of that short time limit puts quite a lot of pressure on somebody to just put a claim in, because they think, well, hang on, this might have been unfair, it might have been, something like that. Certain situations, let's go back to the maternity situation. If you've just been dismissed and you've just had a baby, you might be thinking, well, I'll put the claim in, and then you're stuck in the tribunal system unless you settle it or withdraw. The 6-month period might mean that people find a new job in that time and just think, do you know what, I'm going to close that chapter and not put a claim in. So I think, while it probably will, there's a hope that it might mean that some people decide not to, or that they're able to settle it at an early stage, or those sorts of things. So there might be more scope for sort of out of tribunal settlements, or even people thinking, you know what, let's close that door, I've got a new job now and my losses are capped.
I mean, perhaps it's a way of hopefully avoiding tribunals that gives more time to negotiate and hopefully reduce the impact on tribunals that all this new legislation will lead to anyway. Yeah, like Jeff says, 3 months is quite short. There is sort of an extension of the limit by the when you're doing ACAS conciliation. Maybe they'll remove the ACAS conciliation and just have it just for 6 months. It might allow for some matters to resolve. It might allow for an employee finds another job and says, is it really worth it? I could focus on my new job. But likewise, it might just lead to the tactic of like the end of month, getting on to beginning of month 5, halfway through, saying, oh, by the way, I'm lodging a claim. If you don't want to be dealing with a employment tribunal claim, you better give me this amount of money, and I'll walk away. So that we'll have to wait and see what the impact is. But I'm guessing it's because of the shortness of the period, and hopefully they're looking at the impact that it will reduce the number of employment tribunal claims, so that there's not as many delays in the tribunal as there currently are.
Okay, great. Thank you. Okay, so shall we just have a quick sum up of what we talked about and things for employers to be thinking about? I mean, I suppose the basic point is a lot of this stuff is still pretty uncertain. Hopefully we've given you a signpost to some of the things which are likely to happen, but I think that the key point is just to stay in contact, and as we get more information, we will of course share it. But any other kind of steps or general points that you think we should bring to businesses' attention?
I think be ready for October. I'd just be saying in the next month we'll get a better idea of what they're aiming to bring into immediate. I think, you know, look at your policies and procedures. Are they non-contractual? Do they have the flexibility to make changes so that you can to align with any new legislation, and look at your contracts, particularly the probationary period?
Yeah, absolutely.
Yeah,
and
absolutely.
the training. Yeah, sorry, Simon. Yeah, definitely. And training, you know, as things come in, and people that will be dealing with these issues, so HR managers, people like that, ensure that you keep them trained, keep them up to date, and so that they know how to deal with any issues that might come in, and share the policies with them.
Yeah, 100%. And just to kind of reiterate what Ross said, I think that's a really important one. You know, the law is going to be changing, and there are going to be procedures within your business that will need to change with it. So making sure your existing policies are drafted in a way that they are non-contractual, making sure that they're clearly stated to be a policy that you can change when you need to. That's going to be really important, because you don't want to be locked into a particular policy or procedure which doesn't kind of fit with the new regime. And I think, yeah, the point about probationary periods, we think that there's likely to be some kind of exception from the day one unfair dismissal stuff if an employee is on a probationary period. So making sure that your kind of standard approach with employment contracts is to have a probationary period where it's clearly set out that the employee's initial work is subject to a probationary period, and they can be dismissed at any point during that if they're for any reason. Okay, so that leaves us with just a couple of minutes for questions before we wrap up. There are quite a few, so we'll just maybe pick out a couple. Ross or Jess, if you saw anything that you wanted to answer, sing out, or I can try and pick something out.
Yeah, John's asked, how can we as business owners make our voices heard before the bill's finalised? The government have said that there'll be a consultation, so just keep an eye out for when that's published. It's usually on gov.uk. Anyone can generally respond, or you can, certain trade bodies, things like that, will put together a group response. So it's going to be through that sort of consultation process, which we don't have the draft yet. So obviously the consultation isn't live, but that's one of the key ways.
Okay, very good. I saw a question about sick leave. Some businesses are assuming that Gen Z are non-committal and will join and take sick leave straight away. What protections can employers put in place to stop or manage this? And I suppose the concern here is if statutory sick pay is made a right from day one, you can see that might increase the instances of someone taking sick leave. I suppose at the moment, if you're kind of sitting on the fence, am I well enough to go into work or not? Well, if I just take one day off, I'm not going to get paid. You might be more encouraged to go in. Making it a right that you get from the first day of sickness, one would think one consequence of that could well be that the number of sick days goes up. Is there anything that businesses can do to try and manage that?
I think one thing, it must be remembered that statutory sick pay is not full pay. So and like I say, I normally see a lot of businesses on a discretionary basis if they don't have a contractual right to sick pay. They normally pay for the first couple of days. So it may be just that, well, just letting you know you're only on SSP, and then it's all about the management of the sickness absence. If there's intermittent absences, it's happening. Like I used to have a client based in Liverpool that every Monday most of the staff were ill. A lot of the staff were ill because Sunday night's a big night in Liverpool, and everyone was sick. So it's getting to grips and making sure, and it's a procedural thing of having that return to work interview and say what's going on, and it might make them think twice about just taking a sick day if it's not genuine. And if it isn't genuine, there's obviously a disciplinary issue there.
Yeah, absolutely. So yeah, having a procedure in place where it's, every time someone takes a day's sick leave, you catch up with them when they return and you try and work out what's going on. I think that's a really good piece of advice, and requesting kind of medical evidence when you need to show that it is genuine. And if it is genuine, you want to be having those return to work conversations anyway, just to make sure that you are supporting your staff. So yeah, hopefully there are some steps that can be taken there. Okay, look, we've come to the end of time. Lots of questions we didn't get to, but as I said, we will try and collate as many of those as we can and put together a FAQ document. If you do need any assistance on anything in the employment law or HR space, there are our contact details on the screen. Thank you so much, Jess and Ross, for taking part today. And as I say, there'll be lots more information on this coming. So stay in touch and we will get that information to you as soon as we get it. Any final thoughts, Ross and Jess?
Watch this space.
Yeah.
Watch this space. I think we'll know soon what they're going to focus on initially, and then businesses can look and plan ahead. I don't think personally that it's going to become law immediately, because they promised that there'll be consultation on it. So there will be probably a 6 to 12 month period to get this right.
Okay, perfect. All right. Well, thanks everyone for joining us today, and have a great rest of your day, and we'll speak to you soon.
Thanks.
Thank you.